Mr. Speaker.
I call Barry Coates.
Tēnā koe, Mr. Speaker. I rise to address the Customs and Excise Bill, first reading. There is obviously a need to update and modernise this bill. We recognise that there are aims and potential improvements in terms of streamlining our customs procedures, reducing the amount of time and cost to importers and exporters, modernising the legislation, and introducing an intention test that would single out those errors by individuals to defraud customs as opposed to those individuals who are accidentally caught up in making a mistake with their customs declarations. So we welcome these aspects of it. We have three major concerns about this legislation. The first and most critical concern is the powers given to customs to access electronic devices. Now, electronic devices for most people are part of who they are these days, particularly those who are under 40 years old. And there's been significant concern from submitters in submissions to the discussion document. There were sweeping powers sought by Customs in the discussion paper, and after pushback from the Privacy Commissioner, Ministry of Justice, which advised caution, political parties, including the Green Party, and NGOs, we saw some limitations that were added to the provisions on access of electronic devices. And the issue here is not only access to the devices, but divulging the passwords and decryption of those devices. Now, there are concerns from submitters in a number of areas. Firstly, for tourists and business visitors, this may be an unwarranted intrusion into their privacy, and they may resent it. Secondly, businesses might be forced to divulge commercial secrets in the process of divulging this information. And there are, for example, consultants who sign contracts which would explicitly prohibit them in releasing confidential information without a court order. Now, there is no court order provided in these powers given to Customs, merely a suspicion or reasonable grounds to believe that there may be a criminal act. There are, in fact, also, thirdly, significant amounts of personal information that we all store on our electronic devices. And personally, I would not want Customs officers to see some of my photographs, thank you very much, of my family and myself in some circumstances. We have our financial records, we have our medical records, we have our emails, and this legislation would also give access to credit cards. In fact, much of our lives is on these electronic devices. Finally, sensitive information may fall into the wrong hands. This is not just a spurious concern. In fact, there are cases such as the switched-on Gardner case where overzealous cooperation between Customs and the police led to the misuse of information. All of these instances from submitters give rise to serious concerns that there are dangers here in the potential granting of powers to Customs that exceed the necessary powers in order for them to undertake their tasks. Furthermore, there are some concerns about how effective this is going to be anyway. Insofar as the power to access devices doesn't give Customs the power to access links to those devices, and these days much of the information is stored on cloud or other storage devices which are remote from the handheld devices. So, in fact, if Customs is after this information, then there's no guarantee that they're going to physically have the information on the electronic device itself. And thirdly, that if somebody wanted not to give over their passwords or their decryption, then they would be fined, as far as we can understand from the proposal so far, $5,000. Now, if we're looking to perpetrate serious criminal activity, then $5,000 is probably worth paying in order not to be found out. So we have some concerns over the effectiveness of these provisions. So the question comes, is the balance right? Customs can already access devices for suspicion of money laundering or terrorism or smuggling if they get a warrant under the Search and Surveillance Act. So the question is the provision of further powers to customs a breach of privacy without sufficient safeguard? And that's our concern. We need a clear threshold and we need due process. And we regard the bill as not having yet provided that in draft form. A second area of concern is increased information sharing with other agencies. Amongst the 91 submissions to the discussion paper, there were a number who raised concerns about sharing of information. Although there are some protections of biometric data, name and intelligence generated by customs, there are still concerns about the sharing of information widely amongst government departments, particularly given the previous incidents of unauthorised release from government departments through mismanagement in the past. We welcome consultation with the Privacy Commissioner and others in order to tighten up some of these safeguards. Finally, there are a set of issues where we would look to ensure that the Customs and Excise Act is actually fit for purpose. And for example, one of those is in the area of transfer pricing. Now, under OECD emerging initiatives on base erosion and profit shifting, the transfer pricing issue becomes absolutely crucial. And we would want to make sure that the bill includes sufficient powers for customs and sufficient safeguards to ensure that that transfer pricing is able to be dealt with, and so multinationals can't get away, as they all too often do at the moment, with shifting their profits to places with low or non-existent tax rates. Mr. Speaker, with those provisos, we would support the bill to committee. We will look to engage constructively in the Select Committee with this bill. We would hope that there will be assurances to these concerns provided in the further development of this legislation. Thank you.